The panel of which I was a member was a panel discussing the revival of hybrid courts and whether these courts were in competition with or complementary to the ICC.
What we've seen is an absolutely remarkable, unprecedented uptick in the number of hybrid tribunals. The last hybrid tribunal before 2014 was the Special Tribunal for Lebanon, set up in 2007. Since 2014, there have been either created or proposed hybrid tribunals in Ukraine, Syria, Kosovo, Central African Republic, South Sudan, Sri Lanka, and Senegal. It's not impossible that within a year or two, there could be more hybrid tribunals than all of the hybrid tribunals and ad hoc tribunals combined.
What struck me is that people are just now beginning to realize the limitations of the ICC, and that given the current world situation, there is a need for other judicial mechanisms to deal with international crimes, horrific crimes, that are beyond the reach of the ICC. I'm not sure these hybrid courts would be either in competition with or complementary to the ICC, because there is a jurisdictional void that the ICC cannot fill. The ICC is not a world court, it's not the world court, it's a treaty court. And unless somehow you're connected to that court through the treaty provisions, then the ICC has no jurisdiction over you. So the hybrid courts fill this jurisdictional void. And can deal in situations that the ICC would be unable to deal because of the limitations of their statutory status.
I'd like to suggest that this subject of discussion is placed in more historical and broader context. A context that addresses, because I think this is the heart of what the question suggests, that addresses the notional character of how internationalized institutions work with national systems in responding to atrocity crimes. I would even argue that we have an evolution that presented a complex situation, a situation which, and this responds, Mark, to the question you asked a little bit, why hybrids are coming up again. It's precisely because in the previous milestones, if we talk about the ad hoc tribunals, there was very limited opportunity indeed for national systems to have capacity to deal with atrocity crimes. And yet, the very essence of complementarity for the ICC is that national systems should take the lead. I think this is related a little bit to Brenda's comment that in establishing the ICC, it was not the ultimate. It wasn't the only institution on the scene. So I would suggest that we need to look at that historical context, broaden the question a little bit more, and understand that this is a field of the law that is quite young, a growing field of practice, a field of the law that will continue to evolve.
The Special Court for the Central African Republic is actually a good example for this. It is the first time that we have, in fact, this situation that there is the ICC, there is the Special Court, and they will now sort of seek to connect on the technical level and see how that actually comes together to a global dealing with the criminality in that conflict. I think that is a novel thing. So therefore, we are evolving. We are moving forward. We just have to be alert and keep mindful of all the lessons learned that we're making, and make sure to note them down and don't commit the same mistakes again. Thank you.
I can sense from my interactions at the diplomatic level that the international community really would like very much to be able to put international crimes and justice and accountability back onto the jurisdictions at the national level. And to the extent that can be done, and you have truly independent and impartial judicial systems that can truly adjudge these cases, that's very good. But there are still many instances in the world where in national jurisdictions they don't have the ability to do this because they don't have control over the areas where the crimes are being committed. They don't have the capacity because many people perhaps have been killed or fled who could fill that capacity gap, or they've never dealt with that complexity of crimes. Or they don't have the willingness because they don't have an independent judiciary, because they don't have a government that's committed to ending impunity and accountability. And in those instances, we need to fill that gap. So I don't think we romanticize the courts. I think they should exist when national systems are unable or unwilling to have independent, impartial, fair judicial proceedings. Thank you.